All right, everybody, let's start our epic webinar for the day. So we have Deepak Raju with us live from Geneva. Deepak is a lawyer at Sidley Austin Senior Associate, and it's an American law firm with its office in Geneva and a global law firm in a way. And so Deepak has been Deepak actually is the only lawyer I know who actually represents states in litigation and investment arbitration at WTO. Last year, he argued on behalf of Canada in a very important matter. I don't know exactly what to share because so many of Deepak's stories are to be censored because of public interest and state interests, and I don't know for sure what exactly to share. But basically, Deepak is a big deal in the world of litigation between countries. Okay, and he has done this in a very short term. And all of you should. I am also proud to share with all of you that Deepak is my classmate at NUJS. We studied in the same class for 5 years. After that, we are also flatmates for a year. It was a great fun year. Deepak is not only a great lawyer; he's also a kind of person. If he's around, there is always a party happening. Okay. So thank you so much, Deepak, for joining us today. So let's do the party here today on webinars, right? So why don't you, give us some highlights of your legal journey or journey as a lawyer so far, and also tell us where you from, your background, where you grew up.
Hi, everyone. Ramu, thanks for that introduction. Of course, I look back at the time when we all lived in that flat in Govalia Tank, Bombay, with a lot of fondness. And it is also in that flat that you decided to start this company and go do things on your own. And I see it's a huge success, so congratulations on that. And we had some good days there.
Absolutely.
At the end of this session, I'm hoping you can also sing some of those songs you used to sing in the house for your One minor factual correction on something you said. So last year, the case I argued was for Qatar, not for Canada.
Okay, I'm really sorry. Okay.
That's fine. So there were two cases for Qatar, and I had the opportunity to do part of the oral arguments. But before we get there, to answer your question on background and milestones in the journey. So I'm from a place called Nedumkandam in Kerala. Nedumkandam is a very, it used to be a small village. Now it's a small town. And it's in a district called Idukki in Kerala. It's a very scenic place close to...
Which you keep telling us about, but never took us there.
I asked you to come to my wedding and you disappeared under mysterious circumstances. So I'm not going to go there.
Okay.
So yeah, I grew up there. I studied there till class 10. And then I moved to Kottayam district in Kerala for my class 11 and 12. And then I spent a year in Bangalore doing something and moved to Calcutta for law school. That's where Ramu and I met. We were classmates. 5 years of great fun in NUJS. And at the end of that, I joined a law firm in India, Amarchand Magaldas in Bombay. That's when we lived together. There I was part of a team called Financial Regulatory Practice. But the whole time I wanted to do something in public international law because I'd done a fair bit of moot courts in college and I'd done the Jessup moot. And the whole idea of that, Ramu, I just got a message saying people are having difficulty.
No, we can hear you clearly. You are clearly audible. Guys, can you hear Deepak clearly? If not, or if you can't hear him, write no. If you can hear him, just write yes. It is audible. I can hear you picture perfect. No issues at
all. Okay, then I'll proceed.
Proceed.
Okay. So I wanted to do something in public international law because I've done the Jessup moot court and pretending to argue cases.
Okay, I'll stop you for a moment. I'll stop you for a moment. To hear, okay, you have to use a earphone, like you use a headphone or earphone or whatever works. Okay, sometimes you may not be able to hear because your equipment may have certain settings that you need to change. Sometimes you have to you can do that. Okay, you can fix it from your Zoom also. In Zoom, right next to the button which says mute, okay, and the mic icon is there. Next to that, there is a small arrow. And play around with the settings, and you'll be able to fix it. But I promise you, it's working on our side. It's working with so many people. So if there is some issue, please just use a headphone or whatever. It will work. Okay. Okay. Thank you. Okay, Deepak, please carry on. I'm sorry for interrupting.
Yeah, no problem. So yeah, doing. Okay, Rukmini is bringing me headphones, which might make things easier. Give me a second. Those won't work. Sorry. We'll continue.
Let's just
continue
go ahead.
The way it is.
Yeah,
okay.
Yeah.
So yeah, doing the Jessup Moot Court, I thought public international law was this area I wanted to enter because pretending to argue cases for states seemed like a lot of fun, and I wanted to do it in real life. So after less than a year at Amarchand, actually we all sat together and made a collective decision to quit our respective jobs and do something different, Amu.
Yes.
And from there, I moved on to Delhi to a smaller firm called Claris Law Associates, where we did WTO law to some extent and investment advisory work as well. So I spent a few months at Claris, and then I moved on to Cambridge for my LLM. And that was an LLM focused on public international law. And at the end of that, I came to Geneva as an intern at the appellate body of the WTO. And while I was doing that, I met someone accidentally who happened to be a partner at Sidley Austin. And he told me that one of my professors at Cambridge had previously worked with Sidley, had said some nice things about me. So he invited me for a coffee. So I turned up for a coffee and thought of it as coffee, but I saw 3 senior partners sitting across the table from me, and at some point realized it was an interview. And that led to a job at Sidley, and this was in 2014, so that's 6 years back. So for the last 6 years, I've been in Geneva working with Sidley Austin. Most of my work is with Sidley's trade team, so WTO disputes. That is disputes between countries relating to international trade, how governments can interfere in international trade and to what extent. And that has certain rules, and whenever a country feels someone else is violating the rules, they can bring a dispute at the WTO. So that has been most of my work at Sidley. But I'm also doing a bit of work on investment arbitration, which is when a foreign investor finds that the government of the country in which they're operating has taken certain actions which hurt them in specific ways. They may enjoy the protection of a treaty, a bilateral investment treaty, or another international investment agreement. And those treaties may provide for arbitration, and that arbitration happens in front of a tribunal which is supposed to be neutral and independent from the influence of the country against which the complaint is brought. So that's another area in which I've been doing some work. But in addition to that, as I told you, my interest is broadly public international law. These are all pieces of public international law, but I also try to keep the broader interest alive and offer advice on broader public international issues as and when they arise.
What would be like if I say that what would like 3 things that you have done in the last 10 years in your career that you look back and you are truly proud of?
Right. Well, if you ask me to pick 3, one of them is arguing a case before a WTO panel for the state of Qatar. That one was special because it involved a boycott of Qatar by a number of its neighboring countries. And legally, it involved a provision called the national security exception in the WTO agreements. So this is a provision which has existed for a long time on the books, but there was an assumption that this provision is self-judging and there's no point litigating a case when a country says, oh, we did this for national security. So for a very long time, no one had litigated this case. But in the last 2 years, suddenly there's a series of disputes at the WTO where countries are challenging measures taken by other countries, even when they say it is justified by the national security exception. So it's a very important issue. And I, as you know, I'm a young lawyer. So the opportunity to make arguments on that particular issue were quite special. And that dispute also gave me the opportunity to speak on a number of public international issues, which was quite fascinating. So that was definitely one of the top 3 issues. Another aspect of my work that I've been particularly proud is something relating to aircraft subsidies. So, you know, the big aircraft, the big airplanes that you fly in, there are two companies that produce it worldwide. There's Airbus and Boeing. And for a long time, there's been a dispute between the European Union and the United States about government support to each of these companies. So each side says that the other side is providing subsidies, which are skewing the market and providing unfair advantage to one or the other of the companies and causing harm to the other. So that's been a very interesting dispute, which has been going on for a long time. And I've had the opportunity to work on that on behalf of Airbus and work closely with the European Commission and the lawyers there. So that's been a fascinating dispute, both legally and in terms of getting to know a business. I've had the opportunity to visit one of Airbus's facilities, to meet some of their senior people, to truly get to know how the business works. So that has been a truly fascinating experience as well. And for my third, I will actually pick a pro bono client. So sometimes we step outside of what we do typically, disputes between countries. We also have some pro bono clients to whom we offer advice. And those may be garden variety contractual disputes or commercial disputes. It's an attempt to sort of step out of what we do every day and get a little bit of new experience. So we had one particular client who was a coffee producer in Tanzania. What he did was start a coffee mill in Tanzania, and for about 100-kilometer radius of coffee producers, or even more, he was the only coffee mill in that area. So for a lot of people, this was the only way to sell the coffee that they were producing, right? And he had borrowed some money from investors, international investors, to start this facility. And at some point, the equipment that he bought with this money was not functioning, and he fell behind on paying the debt. So we came on board and we became counsel for him. And we spoke with the creditors, and it was not a particularly challenging task because the investors, the creditors, were also publicly spirited people who had advanced money for a good cause. And all they needed was a reasonable understanding on when the money was coming back. So having that conversation with them, when we entered the picture, we were able to not only get them to refrain from suing our guy, but we also got a 2-year grace period during which no interest would accrue. We even got him more money. So the creditors said they would even offer him more money to keep the company going so it could generate revenues and pay them back. So that was also quite a special experience because it is real people. And when you're litigating for states, there are times when you don't really meet the people who are affected, who are really affected on the ground by things you do. So this was a little bit different in that we were dealing directly by somebody who's affected by what we were doing, and happy to have done something like that for a change as well.
That's such a great story, Deepak. I remember you telling me when in Bombay that your dream is to go and essentially argue matters in the International Court of Justice in Hague. Have you done that yet, or are you
No.
being too humble?
No, so ICJ is a forum where I have not had a case yet. And it's a forum where I still hope to have a case someday. So as I told you, we currently focus a lot of our work on WTO disputes and investment arbitration. And these are areas in which Sidley has had a very long track record. Now, some of the disputes that we do have more public international law components to it, and I get to work on those. Sometimes a problem that a client faces is multifaceted and cannot be solved in one particular court or tribunal. So they may have a WTO dispute, have an investment dispute in addition to that. And along with all of that, they may have a dispute at ICJ or another forum. So one of the disputes that I'm doing currently, that's the one with Qatar, involves a number of ICJ cases in addition to the WTO disputes. I'm not representing, I'm not acting in the ICJ case, but I work very closely with the people who are working on the ICJ cases on a number of issues, and we sort of coordinate to make sure that we're all saying the same thing and we're not saying something that contradicts each other. So that has been a fascinating opportunity to see people working in that particular forum. And that's a forum that I'd definitely like to have a case before at some point.
Right. That is so awesome. When people come and ask us that, can we really have a career in international law? Most of the time our advice is, I don't think so. It's not a realistic plan. There may be 20 or 30 lawyers. I may be totally off the number that I'm saying, but I don't think more than 20, 30 job opportunities get created in this area in a year for a full-fledged lawyer, right? I don't know what is the scenario on that aspect. Why don't you throw something?
Well, so I think it's not, I wouldn't be as pessimistic about this. So if you want to have a career in international law, there are multiple ways to have it. Arguing cases before a court or tribunal is only one of the many ways you can be an international lawyer. You could actually join a government.
But how many lawyers are there in the world who actually regularly argue sovereign state disputes?
Well, actually, there's an article called The Invisible College of International Lawyers. And recently, someone had done a statistical study. I forget what the number is, but I think overall, it's probably 100 people or 100 and 200 people maximum who argue cases before, orally argue cases before international courts and tribunals, all of the courts and tribunals put together.
And that means that out of these 200 people, if you're talking about new jobs getting created in a year, it's probably not 10 or 20.
Right. And also when you create a job, when you have a new job, it's not necessarily a job which says you're going to argue a case orally before one of these courts or tribunals. A lot of the work that we do is also writing submissions, right? So in
research
sense,
also, I'm guessing there will be research and other work.
Yeah. So a lot of the work is behind the scenes when you're thinking, brainstorming, strategizing, and writing. And in reality, you have probably Ramu.
Go on. No problem.
Yeah. So in a real sense, in my practice, WTO law, you probably have 3 or 10 days a year of actual court where there is oral argument. The rest of the time is spent in writing, reading, and strategizing. You're working up towards those oral hearings, and those oral hearings are important, they're exciting, but a lot of the work is in the background. And when you do have those days, it's a little bit different from the Indian court system. WTO panels, in each case, they have usually the original panel, the panel before which you first go. Usually they have 2 oral hearings. And for that, they block off 3 days at a time. And that's the only thing they do. And that's the only thing you do during those days. So it's a full-time hearing. Every issue is thrashed out. So it's very exciting. But it's not most of what you do during a year.
So what do you do? So there are 2 questions now. I think you have started answering 2 different questions, and both are fascinating. One is that what work do lawyers like you do? Okay, number 1. If you are going to work with sovereign state disputes, then what does your day look like? What does your year look like? That's a good question. The other question is, how can I have a career in this area if I want it? So let's start with the work. Let's understand what's the work like first.
Yeah. So in terms of work, usually what we do is usually our clients are states. Okay, that's a bit of background. So we have a lot of state clients, and we also have certain companies. Now, the reason why I say a lot of the clients are states is because in the WTO, the World Trade Organization, it's only members of the organization, which are mostly states, who can actually bring a dispute. But the problem that they're complaining about may be faced by a company or by an industry. So they may be doing this because one of their companies or an industry faces a problem, but formally it's a state that can bring a dispute. So a lot of times we act for the state which brings this dispute. Sometimes we also work for the company or industry which is affected by the underlying problem. So usually a client comes to the firm that I work with, Sidley Austin. They say, oh, we have this problem. And when they say we have a problem, we try to understand whether or not that's a legal problem, international legal problem. And to the extent it's a legal problem, which forum can we take it to? So sometimes clients come with the understanding that sometimes clients already have an understanding this is a WTO dispute and that's where we're going. But a lot of times what we get is a problem and we need to find, is this a legal problem? Where do we take it? Once you decide where you're taking it, say WTO panel, there is a phase when you're strategizing with the client, and the client, if it's a state, needs all kinds of approvals, all kinds of decisions from the highest political levels to bring a dispute like this. So you're providing them a legal analysis, which will enable them to make a decision at the highest political levels to launch a WTO dispute. Once you make that decision, there's a process called consultations when the 2 countries try to sit together and talk about the problem. But in WTO disputes these days, it's become essentially a formality. There are some times when parties engage in consultations and provide information. Sometimes it's a formality. So you have to make a request for consultation, which is the jurisdictional document that you write, and that starts the dispute. In the initial stages of the dispute, you also spend a lot of time gathering evidence. And that process can often be interesting and challenging.
I remember the interesting part when you got some Cuban cigars as evidence.
Yes, that too. That is the plain packaging dispute when we all had cigars laying around. And well, one of the partners that I worked with had a lot of cigars and cigarettes in his office, although he was not a smoker, because that is part of the evidence. So that was pieces of evidence that came to us without a lot of attempt. But in a lot of disputes, looking for evidence is actually a very challenging and interesting exercise because there's all kinds of sensitivities about information. So sometimes a company has information which is extremely helpful for a dispute, but that information is also particularly sensitive and they don't want to share it with the rest of the world or with their competitors. And there's all kinds of mechanisms to protect that information in the WTO rules. So we have to abide by them, we have to provide all kinds of assurances to the party. Sometimes information is politically sensitive and we're interviewing somebody who's either in the government or in the military or in a trade department. So they may have documents, but again, that requires a lot of approval processes. And this process lets us also meet a lot of interesting people. And at the end of that process, we have an evidentiary record, and that allows us to start writing our submissions. So in the course of a regular WTO dispute, the first stage, the panel stage, you would have about 10 written submissions by each party. And each of them is fairly detailed and long these days, hundreds of pages, and quite a bit of evidence. And once you have this written product, at least the initial batches of the written product, the panel invites you to an oral hearing where parties exchange views. So most of my time is spent in evidence gathering, processing, writing submissions, brainstorming, strategizing. Some of my time is spent in oral hearings. That's the exciting part. Now, at the end of all of this process, what results is what we call a panel report. So the panel's decision is handed down as a report, and you may have an appeal from it. So that's all. There are multiple stages to a dispute. And at each stage, so when you're starting a dispute, you need to have a strategy which you agree with the client. As you go through the process, some new strategical questions may arise, and that's again an opportunity for you to be coordinating with your client. And once you get the product, once you get the panel report, there's also a process when you're digesting that report and you are explaining to the client what it means, because these are hundreds of pages long. And based on the panel report, there's actions to be carried out. The clients need to know what they can and what they cannot do based on the panel report. That's again another strategy heavy stage of this process where you are essentially brainstorming and coming up with strategic advice. So these are all bits of what I do. It's a lot of sitting in my office and thinking, reading, writing, and a little bit of going to court. I thought you asked two questions. What is the second?
Yeah, so this was the first part of the question. The second, so is it a very busy job? One of the things that I'm sure all the law firm lawyers are thinking, that, oh my God, if I work in a law firm in India, it is crazy, right? So how is it to work in Switzerland? What you spoke about the content of the work, but you didn't say anything about that.
Right. So in terms of how it is to work here, I've thoroughly enjoyed it. The work culture is a little bit different from India. So it's a little bit more of a flat hierarchy. So of course, in a law firm, you have a hierarchy, you have partners, you have associates, but the hierarchy is a lot more flat here. At a very early stage, you get to take responsibility and do things on your own. Of course, you have guidance, you have supervision, but you get a lot of your own space. And I find that quite important when you try to grow your career. So in this particular dispute where I was arguing the dispute for Qatar, I was in the room with one of the very senior partners who actually started this practice. He was one of the people who came to Geneva and set up Sidley office here.
What's his name, if I may ask?
Scott Anderson. So he actually set up this firm, and I was with another partner, Ian Sanford. So both of them were the senior people leading our team on this. Now, when we were going for this argument, I asked Scott, what parts of this do you want to argue and what parts do you want me to argue? And of course, Scott is somebody who had been in Geneva in WTO dispute settlement for a very, very long time. He's actually the first person, one of the first people to start a private practice in WTO law, private law firm practice in WTO law. So he's a very senior guy, and I asked him, what do you want to argue? What do you want me to argue? And on the issue that I was handling, he just told me, you argue, my job is to tell you when to shut up. So he was giving me the microphone and I was arguing, and he would simply write his recommendations on a little piece of paper saying, oh, you've said enough, shut up. Okay. And he was doing the role of sort of keeping an eye on things, supervising, but let me do my thing. And the other partner I mentioned, again, said he was happy to play the role of the director of traffic. And I was doing this with another person. So there was another associate in the room who was also arguing. And he was also 30-something. So both of us in our 30s had a lot of time to make arguments, a lot of freedom to say things, while the senior colleagues were there to guide us, help us. And of course, they had valuable arguments to contribute, but they were happy to yield the floor, very comfortable with letting us take the floor. So that's the kind of independence, responsibility that you get at a fairly early stage here. And I have a colleague who argued before the WTO appellate body when she was in her first year. Very first year at Sidley, she argued the whole case before the WTO appellate body. So that's the kind of responsibility you get. In terms of timing and how long do you work, this availability of responsibility also has a direct consequence for how long you spend working. There is no concept of face time here, so you don't really have strict working hours. You can work from home. A lot of my colleagues typically do that. There are people who spend 1 or 2 days in a week working from home or working remotely. You can not go into office if you don't have meetings and if you don't have anything to do. But when you do have work, it's your work, you need to do it. So on average, what does this translate to? Almost everyone is out of office by around 7 o'clock in the evening. There are days when I spend longer hours. In my 6 years, I've had an all-nighter probably 2 times. So yeah, there is a lot of work, but it's not crazy hours. It's not all-nighters very frequently. As I told you, it's 2 all-nighters.
And it's not volume, it's quality work and not volume of work, right?
Yeah. So it is quality work. It is,
you're intellectually satisfied with the work.
It's intellectually satisfying. Typically, you get 2 to maybe 4 disputes in a particular year. You're working at any given time, you're working on somewhere between 2 to 4 disputes. And each of these disputes takes a couple of years to finish. That also allows you consistency. You know what you're working on. It allows you to plan in advance for things that are coming your way. And that sort of helps with arranging the workload. So yeah, when people say they have all-nighters all the time or they work long hours, I fortunately don't have that situation. It's a lot more manageable and it's satisfying.
Okay, that's so amazing to hear. Very few lawyers say that they have great work satisfaction and great work-life balance, and forget you have a very good schedule also, which is wonderful.
Yeah, I'm lucky in that way. So I think it's also part of the work culture that senior colleagues set. So everyone in my office has an interest outside of work, and they make sure that they balance those interests with work. They're all great at their work. They all enjoy their work, but they're not people who live and die for this alone. So for this work alone. So one of my senior colleagues plays in a band, and he makes sure that he is out of office at a certain time because he has to be at a bar playing with that band. Another colleague is a runner. Well, many of my colleagues are runners, and they make sure that they go out and do their run during lunch. right? And these are the senior people. So once they set the tone where they balance their work and hobbies and families and all aspects of their life, uh, it sort of incentivizes everyone else to follow suit, and it tells you you don't really have to kill yourself or become a one-dimensional creature to succeed.
Wonderful. So I think that is so important, and many people are, I see in the comments of saying first world lifestyle, but truly, like, even the lawyers who do really well in India and are really busy and manage to stay busy for many years have very good work habits like this, and you can't burn yourself out in a matter of years. So that's wonderful to hear, and I hope someday Indian lawyers will figure out how to work like this rather than killing themselves. And literally, like, people, so many people, lawyers are having mental health issues simply because of unsustainable work habits. So such a great thing to hear. If you can tell me, next question. Now people are super impatient. They really want to know how to do this work, right, after hearing everything from you. So why don't you please tell us this thing? And I'll request, see, I understand probably some of our friends have joined into chat, and I request not to be rude in the chat. I'll have to shut down the chat. Okay, so please, I understand. It's harmless to have a little bit of fun, but let's not overdo it. Okay, so there are a lot of different people who may not like this. Okay, so let's just keep the fun for later. Okay. So Deepak, that big question: how to get into this?
So how to get into this? There's no set path, first of all. And when I came out of law school saying I want to do public international law, there wasn't really one path that I could pick. I actually didn't know. I made up a plan as I was going. And as I told you, I bumped into someone on the street, and that's how I got this job. So that's, of course, not something you can replicate. But having seen many of my colleagues and the paths they have come through, usually when you speak about getting into public international law, some areas of public international law are easier to get into and more institutionalized than others. One is WTO dispute settlement, the other is investment arbitration. So one way to get into those fields would be for you to do a specialized LLM in international law or in any aspect of it. And while you're doing it, meet the right people, make sure that you make genuine connections, people who will remember you and will lend you a helping hand when an opportunity arises. As I told you, one of my professors recommended me for this job, and I had not asked her to do so. I did not even know she was doing it. She genuinely did this because she was genuinely a nice person, and for whatever reason she thought.
And you must have she must have she found you to be promising, right? So that was also,
yeah, I hope so. So of course
let's not be humble, because people are trying to decide their careers. Okay,
right.
Your humility will interfere with their career plans.
Of course, she had seen me. Of course, she had seen me in class, and that is the basis on which she made the recommendation.
So how hard it is? Let's be honest, right? What is the I would say, how good a lawyer you have to be to really make the cut?
Well, so as I said, there are very few opportunities in this field. And if you want to be in this field, you have to be an excellent lawyer, and you have to stand above the competition. And
we are talking about probably 0.1 percentile, right? Like you probably have to be, your intelligence level should be it's, by the way, intelligence you can develop, no problem. But the point is that it is super exclusive. Let's be clear, right? So you cannot.
Right. But it's not just intelligence level also. So when you speak of an excellent lawyer, when you speak about the top cream of lawyers, it may mean different things for different people and in different sectors. For instance, there are excellent corporate lawyers who do things that I just don't understand. There are lawyers who are doing work on blockchain. I'm yet to understand what blockchain is. And they all do fascinating things and they need certain skills. What an excellent lawyer for this particular field means is somebody who's able to see problems, broad problems, make strategic decisions, work quite hard, connect with people at a human level. So these are a couple of pointers. This is not an exclusive list. And something that's particularly important is when you're dealing with states, the sensitivities, and what you're doing in one particular dispute may have knock-on consequences for something you're not dealing with. It may have consequences 10 years down the line. And you need a sense, a strategic sense to sort of appreciate what these consequences are, foresee them. And every word you use may have those consequences. You need to be able to be careful about those things. So that's a particularly important skill in this field. And also, if you are working in international disputes, you're going to meet people who are from all over the world, simply by the nature of this job. And you need an ability to connect with people who may be very, very different from you, may have very different styles or value systems. You need to be able to connect with them and get things done. So that is a very important skill to have as well in this field. Now, I'm coming back to your question on how to get into this. So once you finish an LLM, typically there are a number of internships that you can do in this area. The WTO has internships for lawyers, which is 3 months to 6 months. And it's a great experience if you get into one of the legal divisions. I interned with the Body Secretariat. So you get to see how the judges work from behind the scenes, and that gives you valuable insight. It's also a very interesting place to make connections. And law firms, when they're looking to hire, tend to value that experience very highly. We have a 9-month trainee program for our trade and arbitration teams. And that's usually somebody who has finished their LLM. And some of them also come with a fair bit of experience. So trainees get to work very closely with the remaining lawyers on disputes, and they're an integral part of the team, and that's a great learning experience. And some of our trainees have gone on to become full-time colleagues. The International Court of Justice has a clerkship program where they hire people for a year, or I think it's a year or two, where you're assisting a judge at the ICJ. And I know some people who have done that program and have done excellently at their careers after that. So these are a couple of the opportunities that you can look at.
Wonderful. If you look now I am super tempted. When you make a partner, I'll keep a track of that. I'm going to come and tell you to give me a job.
Well, as long as you let me crash in your Goan villa and hang out with the kids and play guru for the rest of my life, yeah, happy to.
Done. Okay. So now, I think I got a sense of this. Now see, while I kind of take pride in the fact that I specialize in getting kids through to the jobs that people thought they won't get. Okay. And this sounds like a perfect thing. So I'm going to bring some of my expertise from that area. I'm going to ask you questions. You tell me, do you think this might work? Okay. So one thing I would think, if I was there and trying to get one of these jobs, I would think of starting to write a lot on these areas and start publishing. Okay. I might want to, doing webinars like this, for example. What if I start a series of webinars where I invite these lawyers to come and share? Not a lot of is being talked about it. I am sure they would be happy. Some of them would be happy. If there are 200, maybe 10 of them would be happy to share their insights. That is one part of it, of course. The other part is that I can figure out that what are they trying to do that they are not maybe doing very well. So for example, I might want to see if your law firm would want to start a podcast or a YouTube channel, uh, or something. I don't know, it could be something else, a blog or newsletter or something, to reach out to more potential clients. And I would see if I can at least pay the techie in that, right? Probably I can figure out the podcast production for that, and that would create a relationship and connection, and that might open doors. I may even try to kind of visit those places and spend time and hang out and get to know more about the people, because one-on-one meetings, like what you said, is so important, that you just bumped into it, but it is not just bumping into it. You did all the right things. You had for example, your job at Claris, many people would have said, what is this you are doing, Deepak? What, even I didn't understand what the hell we were doing, because you left, you were working directly in Cyril Shaw's team in Amarchand, you are getting paid more, and then you left from Bombay, you moved to Delhi and started working in the smaller law firm at a lower salary. Why exactly, right? But you were pursuing your dream. So you were on track. You were building up your track record in international disputes in whichever small way you could. And then you went abroad to do your master's. And because of all this accumulated experience, you seemed like a very smart person in the area, and you look like the right candidate, right? So you have done a lot of work before to put yourself in that position, right back from college when you were doing JSUP, right? So I think that's a critical thing, that building track record, and not everybody has to build track record in exactly the way you have done, but people can build track records. What if you start writing reviews of JSUP speakers or arguments? Okay, you just start writing reviews on that, or start a blog around that. You'll connect with so many international law enthusiasts. Some of them might be partners at Sidley Austin or another law firm. So do you think this direction works in any way? Do you think it's or am I just imagining stuff? What do you think?
Right. So, as you said, there's no one way to make a track record, and making a track record is important. So when I interviewed, my publications were quite important. I'd written a fair bit on investment law, and a lot of it was newspaper columns or journal articles. And that was something that they looked upon favorably. And it shows that you had a consistent interest in a particular field, and you're able to express your ideas, and you have made an attempt. So it's great to have a track record. Now, talking of podcasts and YouTube channels, of course, you can do that. And it's actually something that law firms are increasingly looking at as well. We have a number of colleagues who have been doing podcasts recently. Sidley has a podcast. I don't know if it's called a podcast channel, but I'm not a techie. But we have a series of podcasts where some of our colleagues are speaking about things like Brexit or the impact of COVID and on certain kind of contract or treaty clauses. So it's, of course, a great idea to do things like this, where you're staying abreast with legal developments and giving your own opinion on something and putting it out there. So, Ramu, you probably know that I used to run a blog called Lex Arbitrary with Rukmini, who's my wife and girlfriend. So that was a blog where we were tracking developments in arbitration world and providing our 2 cents. And that was also something that counted towards building the track record. So there is no one way to do it, and do it in any way that you think you can be good at. Another thing that I've noticed here is, at least in Europe, it's very normal to write to someone and say, do you want to grab lunch? Someone you don't know or someone you've met socially, right? So it's totally normal to send somebody an email saying, okay, I'm so-and-so, I'm interested in your work, can I grab lunch with you? And most people, most of the time, say yes. And that gives you an opportunity to know people, take their guidance, and sometimes opens doors. So I don't know if that culture persists in India yet, whether it's that common yet, but here, even with the most senior people in a particular field, you can easily do that. And it's a very healthy thing to do.
And it
I
is so
meet
in
with a
India
lot.
also. It is not very different in India. Trust me. It's just that people don't do it, right? If
Correct.
you write to people, and this is, I'm happy to share publicly, a lot of our students who are saying, I'm not getting jobs and this is not happening. I say that, okay, you do 10 informational interviews. Just write to people in the firms who are 5 years ahead of you in their career. Tell them that, can I come and meet you for 10, 15 minutes and grab a coffee? I promise I'll not take more than 15 minutes of your time. And these are some of the questions I have on my mind. Even you can say that. And nobody usually says no. And it's a great advice for people who want to go get work from abroad. I think you can just write to people saying, on these dates, I'm visiting this country, your country, would love to meet you in person. And people say, out of curiosity, they say yes, that who's this person coming from another country. So those things may work, right?
Yeah, of course. Yeah, and also go to events around your field of interest. So there's a lot of interesting conferences that happen around international trade law or international law in general. I tend to go for one or two of those every year. Uh, Now, of course, be careful in choosing which ones you go to. You should see who's coming and what kind of topics are being discussed and what you can do when you go there.
Why not
So,
even organize some events? So organizing
of
events is
course,
so easy now,
of
right?
course, if you can organize events, that's even better, and that's
And my suggestion is volunteer to help the organizers, even
yeah,
before you
yeah,
organize. So
exactly
many of them just agree, and you just get access to all the speakers if you're a volunteer.
right. Yeah, and Geneva, there's a huge well, trade community nowhere is huge. Trade community worldwide is small, but Geneva has a big chunk of that. Uh, so if you find internships or other opportunities to be in Geneva to spend some time here, I think you should do that. And that is definitely a way to meet a lot of people in this community. Unless you find them in India, if you can find those internships, especially at the WTO, it pays you a subsistence stipend to live in Geneva and gives you access to a lot of people in this very small community.
Wonderful. Wonderful. So, you know what, Deepak, we have 2 minutes left according to the clock, but I don't mind stretching this a little if you are okay with it too.
Yeah, sure.
There are
I
quite
can.
a few questions I would like to ask, and there are so many questions from the audience that we haven't taken.
Okay,
Okay,
I
it's
can.
high time you start posting the questions in comments quickly. Yes, Deepak, how much time do you have?
I can stay about 15 minutes.
Okay, that is wonderful. Thank you so much, guys. 15 minutes. Hurry up, all your questions. Okay. Okay, so I am going to open the floor to Sandeep Sheregar. I'm going to give him the mic access. Sandeep, are you still there? Just raise your hand if you can. Uh, the reason for that is that he is a lawyer in India, and he became a lawyer late in his life, and he's doing fantastic work in Bombay courts. Probably if I need to go to a lawyer in Bombay, I probably go to him. And he's also a student of our Master Access. That is how I know a bit about his practice. Uh, if somebody like that says that now I want to go and get some work in this area, or I want to start exploring this kind of practice, okay, is it even possible, or is it feasible, or is it even sensible? So I'm going to give the mic to Sandeep, but why don't you start answering this from what I already asked? Because I think that is a big, major question many lawyers have, that I want, if many people mid-career want to change also sometimes.
Right. So there is no age restriction people enter this particular field. And something I've realized spending time in the West is Western lives are not as linear as Indian lives. So in India, you finish class 10, you go to class 11, 12, get a degree, you work the rest of your life in that particular degree, you get married, have children, you have that whole cycle. But I met a lot of people who decide to change careers late in their lives or start doing something different late in their lives. And that's not really a problem. And one way for you to sort of transition into this field, maybe companies are affected by international problems, as I told you at the beginning. Uh, One of the most common ways for that to happen is governments decide that there is something called dumping, which is essentially a particular
Anti-dumping
product.
duties.
Yeah, a product is being imported at a abnormally low price, or a product enjoys a subsidy. And a country, in response to that, imposes something called a countervailing duty or an anti-dumping duty. And that requires a particular domestic process where you have investigations by an authority. And there's a room for Indian lawyers to get involved, representing the industry which is affected, either the Indian industry or the importer who's subject to the investigation. So that is a great opening to this world, because you will be dealing with anti-dumping duties, countervailing duties, trade at the grassroots level. And sometimes these investigations result in a duty, and other countries may say you didn't do it properly, and we're taking it to the WTO. And a lot of times when they go to WTO, even if they have an international law firm working with them, they may look at the counsel who have done the original work during the investigations to provide at least part of the input. So that may be a way to sort of stay in this field, get into this field at the beginning, and then you can transition into actually disputes at the WTO level. But that's only one example of how you can do it. As I said, how old you are when you come to it doesn't really matter.
I'm going to unmute Sandeep Shegar. But before that, one question that I want you to answer, it came from YouTube. The question is, do Indians get an equal opportunity in this area?
Yeah. So in terms of where I work, we have some statistics on how many nationalities we are. I'm going to give you rough numbers. They may not be entirely accurate. So I think in our Geneva office, we are 50 people who are 22 nationalities and speak about 20 something languages. So we're all from very different places, very different backgrounds. And we all work together very well. It's a great team to work with. And in terms of opportunities, as I told you, I've enjoyed the best of opportunities. I've been given quite a lot of responsibility at an early stage. I've been given a lot of room to.
Basically, Indians are not discriminated against. That is the bottom.
No, not at all. Not at all. And actually, I should also.
Okay, sorry. Go ahead. Yeah.
I should also tell you, it's not just Indians. There are other groups. There may be a lot of different groups that wonder, is this a great place for me to work because I come from this particular identity. We have a diversity officer who takes care of questions of diversity. And Sidley was actually given an award for being the best place for LGBT.
Yeah, but let's not talk about only Sidley. Are other law firms also like this in this area? More or less.
So generally, so the reason I focus on Sidley is because we are the largest team in this particular area.
Right.
We are, of course, a small team, but in this area, we're the largest team.
Okay.
But the other law firms are all the firms that have offices in Geneva. They're much smaller teams. But I've seen people of all backgrounds come into those firms and doing really well. And WTO actually, again, has a lot of people from all kinds of backgrounds. They have a program called Young Professionals, where young people can apply to through a particular route. They write an exam and get into it. That is especially directed at underrepresented countries. And India is actually not one of the underrepresented countries in most years. Some years it is. But India is usually not on that list because there's a lot of Indians in WTO.
Got it. Awesome. This is so good.
So, but I should also let you know that Sidley had this particular award for being the best place for the LGBTQ community. So, as I was saying, you can have all kinds of identities which may be a minority, but it's still a great place to work.
Right. Okay. So, Sandeep, you are online. You have quick 1 sentence, 2 sentences. Ask quickly, please.
Yeah,
we have less time. Yeah.
Hi Deepak, I'm Sandeep here. It's a great pleasure that we are interacting with you live. I have only a couple of questions. Now, you said that there are not many opportunities in the field of international arbitration. Okay, but looking at the world, we are expanding at a very rapid pace. And post COVID, a lot of international agreements are going to be renewed, or international agreements are going to be entered into, especially from the India perspective. So, wouldn't that open up a large number of scope and opportunities for Indian lawyers who would like to practice in the international field of law, be it arbitration or litigation, either of them?
Right. Ramu, can you hear me?
Yes. Yes.
Yeah. Thanks, Sandeep, for that question. So I should clarify, when I said there are very few people working in this field of international disputes, that does not include disputes between companies which are cross-border. So international arbitration may happen between companies or private entities which are in two different countries. In that field, there's a lot of people working on it, and that has always been a interesting area. It's currently a very important one, and COVID may result in a number of disputes that go into that particular area of work. So yeah, keeping that aside, now COVID may also result in a number of state-to-state disputes or state-to-state agreements, which result in opportunities for lawyers in that area. Now, how long that lasts and how much those opportunities are spread, how those opportunities are spread between different firms and between different lawyers is something we need to wait and see. Definitely, a lot of law firms have been advising governments on what they can do in response to COVID and how international law either helps them or constrains them in those responses. We have been involved in that exercise as well. But at the moment, the governments are dealing with a day-to-day management of COVID, fighting fire. Whether or not this leads to long-term sustainable work and increase the number of people in this field is yet to be seen.
Great. So let's take some more questions quickly. Investor brings a claim against the other state mechanism in India. Brazil BIT is a good idea.
Yeah, dispute resolution clauses. And usually there are two different clauses. One is to resolve disputes between an investor and a country, and the other one is to resolve disputes between the two countries. Now, under investment treaties, most of the disputes brought under those treaties have been by the investors, not by states. It's not unheard of for a country to say my investor has a problem and we are bringing a dispute because of that. In fact, that used to be the traditional way of dealing with investment disputes. Before investment treaties became a thing, or before investment arbitration became a thing, the only way for those disputes to be resolved was for a country to say, you're harming my investor, so we are bringing a claim against you. One of the most interesting examples is a case called Barcelona Traction Light and Power Company from the International Court of Justice. Now, while bilateral investment treaties preserved that option for countries to bring a dispute, that option has not been really exercised over a long period of time. And the reason for that may be the investor has the most direct interest in bringing a dispute, and for the country, it's more of a remote problem. So when you've given the investor the tool to deal with the problem themselves, why should a country step in and spend resources on bringing that claim? So whether or not we will see more state-to-state disputes in the future, and whether that's a good thing, we don't know. It's something that we'll have to just wait and see.
There's a question about appearing in exit proceedings as opposed to WTO. Any comments on that? Really, I don't know what is the significance of this question, but perhaps you do.
Right. So exit proceedings are investments And disputes at the WTO can only be initiated by a member of the WTO against another member of the WTO. And the allegation is that there is a violation of the agreements of the WTO. Now, ICSID proceedings are investment arbitration where an investor brings a claim against the country in which they have made an investment. And what they're saying is the conduct of the state has violated some of the guarantees under a bilateral investment treaty. So ICSID has had a lot of disputes in the recent past compared to the caseload of ICSID has been probably larger than the caseload of WTO because state-to-state disputes are a bit less frequent. They also tend to sort of solve slightly different kinds of problems. WTO disputes, the aim of WTO dispute is prospective compliance. So you are looking at a discriminatory tax or a subsidy or anti-dumping duty and saying, oh, we need to find a way to remove it prospectively so markets operate normally in the future. Investment arbitration is mostly about compensation. So the government has taken property or behaved unfairly or engaged in discriminatory conduct that has resulted in some sort of economic damages, and a company is looking to recover that money. So there's a difference in the nature of these proceedings.
So there's a question which is on, one is market conditions generally in Europe vis-a-vis hiring of non-European lawyers, especially Indians, and a lack of, what about fluency in a local language? Is that very important?
I'll take the second one first because that's easier. Local language, at least for my particular area of work, doesn't really matter. I don't speak French except for bonjour, bonsoir. French is the local language of Geneva. It's also one of the official languages of the WTO. So I don't really know French, and it's not been an impediment for me to work in this field. Part of that is because we're working with countries from all over the world. So if I had to learn all their languages, I'd probably need to learn thousands of languages. And there's no way to do that. The other part of it is the way the process is organized. So when you're making arguments at the WTO, there is simultaneous interpretation into all of three official languages. So you may be speaking in English while someone else hears that in Spanish or French. Someone else may be speaking in Spanish or French while you're hearing it in English. Now, we do get documents which are in a number of different languages to review, and that becomes part of the evidence. And we have professional translators who translate that for us. Now, in investment arbitration, I know sometimes knowing a language can be a leg up. So there are times when law firms are looking at volumes of documents in, say, German or Russian, and somebody who knows that language would be an asset. So I know some of the arbitration teams who have paid attention to language skills in the past. So if you have it, great, but it need not be the local language of the country where you're going to be working. Now, the other question on how's the market...
That is in this area of work. But I think if you want to work in Europe generally as a lawyer, great idea to learn local languages, because that is the only way I think in many cases get a job. Not in this area, but other areas.
Right. Yeah, so if you want to serve private clients on domestic law, of course you need to interact with them, and you'll need to do so in the local language. Now, the reason why I said for me it doesn't matter is because I'm working not on Swiss law. I'm not really working with Swiss clients. I'm working on international disputes with countries which are all over the world. Right? Now, on the market conditions in Europe, so it differs between different European countries. So there's the European Union market, there's the UK market, and there's the Swiss market. So Switzerland has a work permit requirement which prefers Europeans, and only if we cannot find Europeans to fill a position, a vacancy can be offered to non-Europeans. This work permit requirement has become a little more stringent over the recent years, and it's a bit of a gamble. So when the firm decides to hire you, when any law firm decides to hire you, they need to approach the regional authorities for a permit, and whether or not you get a permit is entirely up to the authorities. And it depends on extraneous factors, really. And the most important is how many permits have been given out that particular year. One way to sort of get around that is to work with international organizations like WTO, for instance, that I mentioned, because they are immune from these work permit requirements and they can hire freely without paying attention to those quotas. Now, in the European Union market, especially in Paris, I've known a lot of Indians in the recent years who've gone to arbitration firms in Paris, initially with a 6-month internship, and have stayed on as associates and have done very well. So Paris firms seem to be very open to taking Indian lawyers, and they don't seem to face as much of a regulatory red tape in doing that. Now, of course, UK, there are people who are better qualified than me to speak about that. There's a lot of Indian lawyers in the UK. I'm not entirely sure I track the market circumstances there, but with Brexit, there may be a lot of new opportunities that Indian lawyers can access.
And do you think overall, as there is more and more work between India and European countries, as there is cross-border work happening a lot, they would need some Indian expertise. And if you're a good lawyer, you can do local work as well as Indian work, and you have a track record in India of doing Indian work, then there is a high chance that you might be relevant. And you don't really need to qualify as an advocate in that country for that in most cases. No. For a consultant, they hire normally.
Right. So that is something we already do. So when we have an Indian domestic problem for one of our clients, or a problem that has a domestic and international side, we tend to work with local counsel. And that's something we do in a lot of different countries. If there is a local law issue, we tend to get local counsel to help us with that. So, and that is also a way a lot of firms have come into practicing in international law area. So they make these contacts by helping in local law, and eventually they decide to take on a larger role. So there are some firms, especially in Brazil and China, which have done that beautifully and have done very well.
Wonderful. So I think this brings us to the end of today's discussion. Really, thank you so much for coming on board and sharing all these insights. I am sure that we couldn't cover all of the things that we would have wanted to ask you today, but another day. But today was great. It was really lovely. So we all learned so much from you. Thank you for joining us, and let's catch up soon again. And everybody have a great day. Thank you.
Thanks a lot, Ramu. Before you go,
parting message.
Before you go, so when we were all housemates, Ramu was the most Bengali thing that had.
I am not singing. I am not singing. That was not singing. That was drunk singing.
Okay. And there is the song Jodi Bolo Ha. Okay, it's a Bengali song, and Ramu used to sing it. But the most remarkable part of it is before the song starts, there's a part where you whistle, and Ramu whistles very well to that tune. And you should know that many years later, when I proposed to Rukmini for marriage, I actually used that song. So it'll be great for Ramu to sing that song to the audience, and at least whistle the initial part.
Okay. Don't you think we should do a different session for all these fun things?
It's always good to keep it fun. So Ramu, let's end with your whistle.
Okay, Deepak, only for you. Okay. Something like that. Actually, no. Okay.
Excellent. Okay. Thanks, Amu. Thanks
All right.
everyone for
Thanks
watching.
everybody. Thanks everybody. Take care. Have a great day.